Hey guys, welcome to Lawyer Stuffs, and today we'll know about contempt of court in relation to the petition filed against senior lawyer Prashant Bhushan. So first of all, let us know that what is contempt of court. In general terms, it is the conduct which disrespects or insults the authority or dignity of the court. सरल भाषा में बात करें तो न्यायालय की अवमानना यानी कि कंटेम्प्ट ऑफ कोर्ट वो आचरण है जो न्यायालय के अधिकार या सम्मान का अपमान करता है. Now, here we have the definition of contempt of court in Contempt of Courts Act 1971. So, the section 2 defines it as follows. In this act, unless the context otherwise requires, subsection A defines that there are two types of contempt: A. Civil contempt, B. Criminal contempt. Now, subsection B defines civil contempt, which means willful disobedience to any judgment, decree, direction, order, writ, or other process of court, or willful breach of an undertaking given to a court. Subsection C defines criminal contempt, which means the publication, whether by words, spoken or written, or by the signs, or by visible representation or otherwise, of any matter or the doing of any other act given below. Subsection D states the High Courts, which means the High Court for a state or a union territory and includes the court of the Judicial Commissioner in any union territory. तो चलिए देखते हैं कि इसका मेन ऑब्जेक्टिव क्या है. ये हस्तक्षेप को रोकने और कानून के अधिकार को बनाए रखने के लिए एक तंत्र प्रदान करता है. कंटेम्प्ट की प्रोसीडिंग्स का उद्देश्य व्यक्तिगत रूप से न्यायाधीशों यानी कि जजेस की रक्षा करना नहीं है, बल्कि कोर्ट के अधिकार और न्याय के प्रशासन को अनुचित हमले से बचाकर जनता की रक्षा के लिए है. दोस्तों, ये एक गंभीर विडंबना है कि लोक आस्था पर गहरी चोट लगाने के अपने आग्रह में सुप्रीम कोर्ट ने निशुल्क भाषण की परेशानियों को दूर करने के लिए यानी कि फ्री स्पीच की परेशानियों को दूर करने के लिए एक निर्णय प्रकाशित करना सही समझा और वरिष्ठ वकील प्रशांत भूषण की सारांशित फैशन में क्रिमिनल कंटेम्प्ट लगाकर निंदा करी. बट व्हाट वाज हिज क्राइम? उन्होंने ऐसा क्या अपराध किया? बस ये कि एक लोकतांत्रिक संस्था की आलोचना करने की गलती के कारण ये हुआ है. संक्षेप में देखें तो ये कहानी है भूषण जी के खिलाफ सुप्रीम कोर्ट में सुओ मोटो पिटीशन के निर्णय के बारे में, जिसके परिणाम स्वरूप अदालत की अवमानना के अपराध के लिए यानी कि कंटेम्प्ट ऑफ कोर्ट के अपराध के लिए उन्हें दोषी ठहराया गया. And this all happened just because of two tweets by Mr. Prashant Bhushan. The Supreme Court is indeed tasked with ensuring that the executive and the legislature are kept in check, that they follow the rules laid down by the Constitution. But the problem with this judgment begins with the registration of the case itself. So now, here we have the first tweet which was made on June 27 and is about democracy and the role of last four CGIs in India. This tweet suddenly reappeared in an English newspaper on the very date, that is July 22nd, 2020, on which Mahek Maheshwari's petition was listed before the Supreme Court. The Supreme Court took suo moto notice of the second tweet, which we'll see further in the video. Perhaps the publication of a tweet made almost 4 weeks earlier on that very morning was just a mere coincidence. So here in this slide we have a chronology of Prashant Bhushan's case starting from date of petition to the day when Mr. Bhushan refused to tender apology. On July 22nd, the apex court had issued notice to Bhushan on the alleged contemptuous remarks on Twitter. The court also asked the Attorney General to assist it on the matter. The apex court had asked Bhushan and Twitter to file a reply by August 5. On August 3, in his affidavit to the top court, the senior lawyer had explained that he regretted a part of his tweet, but the criticism of CGIs cannot and does not scandalize the court. nor does it lower the authority of the court. प्रशांत भूषण ने 134 पृष्ठों का डिटेल्ड एफिडेविट दाखिल किया था, जिसमें 453 एनेक्चर्स भी साथ में थे। इस एफिडेविट में भूषण ने दोनों ट्वीट्स के संबंध में अपना स्पष्टीकरण या बचाव दिया था। प्रशांत भूषण ने एफिडेविट में शीर्ष अदालत यानी कि एपेक्स कोर्ट के कई फैसलों, पूर्व के भाषणों और अदालत की अवमानना पर एक सेवारत न्यायाधीशों और कुछ मामलों में न्यायिक कार्यों पर उनके लोकतंत्र में असंतोष और उनके विचारों का उल्लेख किया है। Now, on August 5, the Apex Court had on reserved its verdict in the matter. Prashant Bhushan had sought a direction to declare that the Apex Court Secretary General has allegedly acted unconstitutionally and illegally in accepting a defective contempt petition filed against him, which was initially placed on the administrative side and later on the judicial side. फैसले का हवाला देते हुए शीर्ष अदालत ने कहा कि उसने कंटेम्प्ट पिटीशन को सुनने के लिए कानून का पूरी तरह से पालन किया था और ये उस सबमिशन के लिए सहमत नहीं थी जिसमें सुनवाई के लिए दूसरे बेंच को भेजा जाना चाहिए। On August 14, the Supreme Court had on Friday held Advocate Prashant Bhushan guilty of contempt of court for his alleged tweets on Chief Justice of India Sharad Arvind Bobde and his 4 predecessors. On August 20, the Supreme Court refused the submission of Prashant Bhushan to defer the hearing on his sentence till his review petition against conviction for criminal contempt is filed and decided. अटॉर्नी जनरल के वेणुगोपाल ने प्रस्तुत किया कि उनके पास सुप्रीम कोर्ट के 5 न्यायाधीशों की सूची है जो लोकतंत्र के लिए खतरे की बात कर रहे हैं और 9 अन्य जिन्होंने सुप्रीम कोर्ट में भ्रष्टाचार की बात की थी, लेकिन जब तक वह अपने तर्क पूरे नहीं कर पाए, न्यायमूर्ति मिश्रा ने उन्हें ये कहते हुए रोक दिया कि उन्हें खूबियों पर सुनवाई नहीं करनी है। सुप्रीम कोर्ट ने अपने आदेश में अटॉर्नी जनरल के वेणुगोपाल के नाम और अदालत में उनके द्वारा दी गई दलीलों का उल्लेख करने में विफल थे। कोर्ट का आदेश कोर्ट की वेबसाइट पर उपलब्ध था। Later, the revised order was issued by Supreme Court which acknowledged the presence of Attorney General. Prashant Bhushan's statement after decision of Supreme Court was that I have gone through the judgment of this honorable court. I am pained that I have been held guilty of committing contempt of the court whose majesty I have tried to uphold, not as a courtier or cheerleader, but as a humble guard. For over 3 decades, at some personal and professional cost, I am pained, not because I may be punished, but because I have been grossly misunderstood. Next, on August 24, Advocate Prashant Bhushan filed a statement before the Supreme Court, retaliating that he'll not apologize for his tweets, criticizing the judiciary over which he was held guilty of criminal contempt of court on August 14. So friends, this was all we had regarding contempt of court in relation to petition filed against Advocate Prashant Bhushan. Thank you so much for watching the video, and if you liked it, then please let us know by commenting below. And don't forget to like, share and subscribe our channel Lawyers Stuffs.